Good morning, everybody. Welcome to the webinar that we're presenting today as we're commencing on the verge of Women's Month. You've got two female SMIEO officials that will be doing the webinar today. My name is Lizca Samuels, and my beautiful colleague next to me, Shannen Brown. She will be assisting me today with the presentation. We will have a Q&A once the presentation is finished. And if you want to ask questions, just make notes of it, and then we can address it after we finalize the presentation. Hope you find this interesting. The presentation of today is the top 10 labor law mistakes employers make. We're just going to share the slides.
Devine, can you let us know if you can see the slides? I just want to make sure, and then Lizca can start.
Hi, Shannon. Yes, I can see everything on my side.
Okay.
All right.
Thank you.
All right. So the first, well, I'll just go through the list with you. The first one is dismissing an employee without following a fair procedure. Number 2, failing to prove a fair reason for dismissal. 3, poor record keeping by employers. 4, ignoring poor performance by employees. 5, applying discipline inconsistently. Number 6 is using outdated employment contracts and workplace policies. 7, failing to conduct proper workplace investigations. 8, failing to consult during retrenchments or temporary layoffs. 9, waiting too long to address workplace problems. And number 10, incorrect management of leave. Now, ladies and gents, we're going to discuss each point, or each, if I can say it, mistake individually, and then we will take it from there. All right, if we go to number 1, dismissing an employee without following a fair procedure. Now, this, for example, is that if at the workplace you find the employee stealing something, company property, and then you just say, sir, pack up your bags, you are dismissed. That is, I think, the most common mistakes employers make. And obviously, an employer may not simply dismiss an employee without following a fair process. A dismissal must always be both substantively and fair. That's obviously a valid reason for the dismissal. That would be the theft. And procedurally fair. A fair process was followed. That would obviously refer to the disciplinary hearing. A dismissal may be procedurally unfair when the employer fails to give the employee a reasonable opportunity to respond before making a final decision. Examples include dismissing an employee immediately without investigating. That's the one that I was referring to now. You get to the employee's workstation or in his bag, you find something, company property, and then you just dismiss him. Failing to inform the employee of the allegations or reasons for possible dismissal. That, ladies and gents, for example, be where you just say to the employee that we're going to dismiss you for theft, and there's no disciplinary hearing, or there's no notice of disciplinary hearing with the allegations, not allowing the employee to explain their side of the story, which would also refer to the hearing, giving the employee the opportunity to state his or her side, and failing to follow the employer's own disciplinary procedures, referring to your disciplinary code or your code of conduct. So once again, ladies and gents, it's important to have a disciplinary code or code of conduct at your workplace, because that would be your guideline in situations like this, all right? The legal position is that the Labour Relations Act 66 of 1995 requires that dismissal must be fair. Employers should generally investigate the alleged misconduct. That investigation is very important. Inform the employee of the allegations. That would be by giving him the notice of the hearing. give the employee a reasonable opportunity to respond. So at the hearing, the chairperson will give the employee the opportunity to state his or her side of the story or the incident. Consider the employee's explanation, and then to make a fair decision based on the facts and communicate the outcome and reasons. So the chairperson would then obviously listen to both sides, employer's version, employee's version, make a fair decision. Yes, sir, you pleaded guilty, or based on the employer's evidence, we're finding you guilty to the charge of dishonesty, theft, and therefore we're then terminating your services because it's a dismissible offense, the nature and the seriousness of the offense, and obviously the trust relationship has broken down. In other words, there was a procedure or process that was followed. Consequences for the employer, and this is the important part, ladies and gents. If a dismissal is found to be procedurally unfair, an employee may refer the dispute to the Commission for Conciliation, Mediation and Arbitration, in other words, the CCMA, or an appropriate bargaining council. And the possible remedies would include compensation or reinstatement or re-employment. So please make sure that you follow the correct procedure or process before just dismissing an employee. There's practical examples. Unfair approach would be an employer hears a complaint about an employee's alleged misconduct, calls the employee into the office and terminates the employment immediately without allowing the employee to respond. The fair process or approach would be employer investigates. In other words, supervisor comes and supervisor says that he found this in the employee's bag. There's an investigation, informs the employee of the allegation, notice of hearing, allows the employee to present their version at the hearing, present evidence, consider all relevant facts, and then makes a decision. A lesson for all employees, or the employer lesson, is that a valid reason alone is not enough. And that is like, we always hear it on a daily basis that, yeah, but he stole something. It was in his possession. It's dishonesty, it's theft. Why should I still go through a disciplinary hearing or procedure? Important, a valid reason alone is not enough. Even where misconduct or poor performance may have occurred, failing to follow a fair procedure can result in an otherwise justified dismissal being found unfair. In other words, if that guy's going to go to the CCMA, the commissioner is going to say that, okay, fine, there is a valid reason, but procedurally it's unfair, and therefore we're going to make an award against the employer for procedural unfairness. So that is the first one. Number two, the second mistake, failing to prove a fair reason for dismissal. So the first one was that we didn't follow a fair process or procedure. This one is that there needs to be a fair reason for dismissal. An employer must be able to show that the dismissal was based on a fair and valid reason. A dismissal without a justifiable reason may be found to be substantively unfair, even if the employer followed a proper procedure. Common employer mistakes, and this happens on a daily basis. Dismissing an employee due to personal dislike or conflict with management. In other words, you don't like Lizca's face and then you just dismiss Lizca. Relying on rumors or unverified complaints, failing to gather evidence before dismissal. And you will notice that the other mistakes that we will refer to during the webinar, during the rest of the presentation, will link up with all of this. You understand? Investigating, you need to investigate allegations. So failing to gather evidence before dismissal, applying workplace rules inconsistently, dismissing for poor performance without setting clear standards or providing assistance, using retrenchment as a reason when the real issue is misconduct or performance, and failing to show that the sanction of this dismissal was appropriate. The legal position, once again, ladies and gents, the employer generally carries the responsibility of proving that, one, a valid rule or standard or requirement existed. 2, the employee was aware of it or reasonably should have been aware. 3, the employee breached the rule or failed to meet the standard. And 4, the dismissal was an appropriate response in the circumstances. In other words, once again, you refer to the disciplinary code or the code of conduct to say that there was a rule of absenteeism. The employee was aware because it was explained to the employee signed for it. The employee breached the rule, and then dismissal was an appropriate response because the employee was on a final written warning or the employee was absent for 6 days, and therefore dismissal was the appropriate response. Consequences of failing to prove a fair reason. An employee may challenge the dismissal once again at the CCMA or relevant bargaining council. If the dismissal is found to be unfair, possible remedies would include, once again, reinstatement, re-employment, or a compensation award. So please ensure, 1, we follow the correct process or procedure. 2, we need to have a valid reason before we dismiss somebody. So like we went through the mistakes, please ensure that you do not do those mistakes. All right. Number 3, poor record keeping by employers. Now, this refers to obviously how you keep record of all your documentation, okay? Poor record keeping is a common employer mistake that can create significant legal and operational risks. In labor disputes, an employer who cannot produce reliable records may struggle to prove that workplace decisions or disciplinary action or dismissals were fair. Common record-keeping mistakes would include the following. Employers often fail to properly maintain 1, employment contracts and written conditions of employment, job descriptions and performance standards, attendance and leave records, disciplinary notices and hearing records, warnings issued to employees. That one is very important, ladies and gents. Grievance and complaint records, training and counseling records, performance reviews and improvement plans, and important evidence supporting dismissal decisions. That would refer to, obviously, if you have video footage and all of that, please keep a record. I know everybody believes in technology and all of that. If you want to make use of that, then you ensure then that you have that on your hard drive or your OneDrive, or the technological place where you can store those information, okay? Legal position is that employers are expected to keep accurate employment records and maintain documentation required by legislation. The Basic Conditions of Employment Act requires employers to keep certain employment records, while the Labor Relations Act requires employers to justify the fairness of dismissal and labor decisions. Examples of poor record keeping. An employer dismisses an employee for repeated lateness but cannot provide attendance records, warnings, or evidence that the employee was informed of the problem. In other words, if we have a disciplinary hearing and then when we get to aggravating factors and the employer alleges that, Madam Chair, the employee is on a final written warning now for absenteeism, the chairperson would obviously request those documentation, and especially if the employer or the initiator makes a statement that we followed progressive discipline, then we would refer to the written warning or the serious written warning, and then the final. You need to have those documentation or those warnings. If we're going to proceed without it, the risk could be that the dismissal may be found unfair because the employer cannot prove the allegations. If you're going to look at an absence charge, then you need to submit the timesheets or the attendance records, or if you're going to say late coming, the clocking. If you don't have that documentation or that record, then we cannot really proceed, because if you're going to proceed, then that dismissal may be found unfair because the employer cannot prove the allegations. Consequences for the employer: poor records may result in unsuccessful defense of labor disputes. Compensation, once again, awards against the employer, reinstatement of dismissed employees, regulatory penalties for non-compliance. If the DOL, Department of Labor, comes and do an inspection and you don't have that necessary documentation, the most common one is a contract of employment, then a compliance order may be issued against the employer. Difficulty managing employee performance effectively if you don't have the work performance reviews or the plans how to improve the employee's performance. The employer's best practice, and I love this, employers should always maintain accurate and updated employee files, document important workplace discussions and decisions. This is also important for me, ladies and gents. If you have a consultation or a discussion with the employee, minute it, document it, record it. So if it gets to the dismissal or the hearing phase, if I can put it that way, then you can refer back to this to say that, Madam Chair, we've started out with normal conversations or normal discussions. Then we went over to the issuing of warnings. Then you can present all of that at the disciplinary hearing. Record warnings, training, counseling, and performance management steps. Keep evidence supporting disciplinary and dismissal decisions, and store records securely and confidentially. If you're going to, for example, anything that's related to the misconduct, please ensure. We've had numerous cases where we could not dismiss the employee because warnings went missing, or an important document that was relevant to the hearing went missing, or it was misfiled. Please ensure that you keep those documentation or you store the record securely and confidentially. A key message for the employers: good documentation is not just administration, it's essential evidence that decisions were fair, consistent, and legally defensible. So it's not just about making sure that it's stored on the OneDrive or it's stored in the file. That would be your key to a successful case at the CCMA. And now, ladies and gents, I'm going to give over to my colleague Shannen Brown that will continue for us.
Good morning, everybody. The fourth mistake that employers make is that they ignore poor performance by employees. It's a common mistake, and it can lead to reduced productivity, workplace frustration, because you get some employees who might feel that they are picking up for others, or that somebody else's performance is being ignored. It also creates legal difficulties when the employer eventually attempts to address the issue. The ways that poor work performance is ignored is that employers allow employees to continue missing performance standards without intervening. So they allow the poor work performance, but they don't address it with the employee and let them know that they're not meeting their standards. They fail to communicate the expected standards and targets. So employees might not know what targets they need to reach, and the employer just kind of leaves them to do whatever they're doing and doesn't let them know that they're not performing up to standard. Employers don't provide feedback, coaching, or training, or they just want to avoid difficult performance conversations. So they don't want to address it. They feel that it might create some conflict. They don't keep records of performance concerns. And then eventually they suddenly dismiss the employee after a long period without supporting them or letting them know what targets they need to reach. The legal position is that there's a procedure that needs to be followed for poor work performance. It's usually a series of consultations. Firstly, the required performance standard needs to be reasonable, and the employee needs to know about it. So at the start of the employment, we can use sales as an example. The salesperson needs to know what their target is or what the goal is that they need to reach. The employee fails to meet the required standard. So if they don't reach their goal or their standard or sales target, whatever that may be, it might be monetary or a number of sales, they need to be told that they're failing to meet that. So the employer needs to give appropriate evaluation, guidance, or assist the employee to improve. And then if they still don't improve, then a dismissal can be a fair outcome. An example of this is An incorrect approach where an employee repeatedly fails to meet sales targets for a period of a year or 12 months. The employer says nothing and provides no feedback or assistance, then dismisses the employee for poor work performance. The risk here is that the dismissal may be found to be unfair because the employee was not properly informed, assisted, or given an opportunity to improve. So that goes with what Lizca mentioned earlier with the substantive fairness and the procedural fairness. Over here to be procedural, there might be a good reason, but the procedure of informing the employee that they are not meeting their standards and going through that series of consultations would be procedurally unfair. The correct approach is where the employer identifies the performance problem, explains the required standard, and explains to the employee that they are not meeting these standards, provides coaching and support, so this would be a series of counseling or consultations, provides them with documents if they need, for example, a job description or they need more details of their targets or standards they need to meet, reviews their progress over a period of time, and then only considers further action if they don't improve. A key message for employers is that ignoring poor work performance doesn't solve the problem. Effective performance management protects both the organization and the employee by addressing the issues early and fairly. So this protects the employer against unfair dismissal. It could lead to disputes where they would be reinstated or, like Lizca explained earlier, compensated. And it also assists the employee to know what they have to do at work as well. Okay, and the fifth mistake that employers often make is that they apply discipline inconsistently. It's a common mistake. We see it often, probably on a weekly basis, where employers want to maybe treat an employee a bit differently. Maybe they like them more than the other, but it can undermine workplace fairness and expose an employer to labor disputes. Employees who commit similar offenses should generally be treated in a similar manner unless there's valid reasons for the different treatment. Employers apply discipline inconsistently by dismissing one employee for misconduct while giving another employee a lesser sanction for the same offense without justifying it. So without a valid reason, maybe somebody was absent for a week and they received a written warning. Their colleague was absent for a week and they were dismissed. If there's no good reason for that, then it's a risk for the employer. Employers ignore misconduct by certain employees because of their position, seniority, or personal relationship with management. So like I said, there might be a bit of favoritism. Maybe an employer prefers one employee to another and they treat it a bit differently. They apply the rules differently across departments or teams, and they change disciplinary standards depending on the circumstances or the individuals involved, or they fail to consider previous disciplinary records consistently. The legal position is that the principle of consistency is important in an important element of fair discipline under South African labor law. The Labor Relations Act and the Code of Good Practice requires that dismissal of employers apply discipline consistently. When deciding whether dismissal is fair, decision makers may consider whether the rule was consistently applied in the past. So that depends on how you've treated somebody in the past. For example, if they have tested positive for alcohol and previously they would get a final written warning for the first offense, but now you've dismissed somebody for the same offense on the first time doing it, then it would be inconsistent as well. They consider whether other employees who committed similar misconduct received similar treatment and whether there's a valid reason for the different treatment. An example of unequal treatment is that two employees arrive late repeatedly. One employee receives a warning while another is dismissed for the same conduct without a reasonable explanation. The risk here for the employer is that the dismissed employee may argue that the employer acted inconsistently and that the sanction was unfair. So they would go to the CCMA, for example, and they would state that there's an element of inconsistency. The employee needs to prove it, But if they are successful in doing so, it would be a major risk for the employer, and the employee might be reinstated or be awarded compensation, or both. Consequences for the employers with inconsistent discipline: it can lead to unfair dismissal findings, compensation or reinstatement orders, reduced employee morale, loss of confidence in management, and claims of favoritism or unfair treatment. So again, this can often happen where there's favoritism. Maybe one employee is preferred to the other and one feels like they've been targeted, while the other can get away with anything. It's a risk for the employer. Employer best practice is that they need to apply workplace rules consistently across all employees. And if you have different teams or departments, that needs to be applied consistently as well. So everyone is subject to the same code of conduct. The employer needs to maintain clear disciplinary policies, consider previous cases when deciding sanctions. So they need to consider what was done in the past. The example that I gave about alcohol as well. If employees received a final written warning for testing positive for alcohol, you can't dismiss one person for testing positive for the first time. So everyone needs to be treated the same, and they need to document reasons where a different sanction is imposed. The key message for employers is that consistency does not mean every case must have the identical outcome. Employers must be able to explain and justify why similar cases were treated differently. An example of this is, like I mentioned earlier, maybe an employee is absent for 5 days, or he hasn't been to work for a week. He has no reason for his absence. He didn't notify management. Then it would be acceptable to dismiss him. His colleague, for example, was absent for 5 days, but he was attending a funeral, or he had a good reason for his absence. Then he wouldn't be disciplined in the same way that the first employee would. The sixth mistake that employers often make is that they use outdated employment contracts and workplace policies. This is a significant employer mistake. Employment laws, business practices, workplace requirements change over time, and failing to update the documents can expose employers to legal disputes and compliance risks. Common employer mistakes, for example, employment contracts after changes in legislation. An example of that is the changes to maternity leave and parental leave. So the contracts need to be updated to allow for those, for the parental leave, where the dads can now make use of that as well, or it can be shared evenly with the parents. Disciplinary and grievance procedures need to stay updated as well. Leave, working hours, and remuneration policies. Remote work and technology policies. This is important, for example, with the IT companies. They need to ensure that their remote work policies are up to date. Workplace harassment and discrimination policies, health and safety procedures, and data protection and confidentiality policies all need to stay up to date. The legal position for employers is that employment contracts and workplace policies must comply with current South African labor legislation, which does change from time to time. So outdated documents may contain terms that are inconsistent with the employee's statutory rights or with current legal requirements. So again, the example of parental leave, if a dad wants to make use of his parental leave, we can't disallow it just because his contract is outdated. That would cause a risk for the employer as well. The important legislation that affects workplace documents, the first one there is the Basic Conditions of Employment Act. This regulates minimum employment conditions, such as working hours, overtime, leave, and written particulars of employment. So employment contracts and policies. The Labor Relations Act. Sorry, I'm not sure what happened there. Sorry about that. The Labor Relations Act regulates fair labor practices, disciplinary procedures, and dismissals. So again, that ties in with what Lizca mentioned earlier with the unfair dismissals, substantive fairness, procedural fairness, that's all contained in the Labor Relations Act and the Code of Good Practice. And then the Employment Equity Act, this addresses unfair discrimination and workplace equality. Lastly is the Protection of Personal Information Act. This affects employee information handling and privacy obligations. So there's policies in terms of the POPI Act as well that need to be in place. The risks of outdated contracts and policies for employers is that, firstly, they have difficulty enforcing workplace rules. If it's not contained in a policy or it's not in the code of conduct, an employee can say that he wasn't aware of it and you won't be able to enforce the rule. Unfair dismissal claims where procedures are outdated or unclear. Contract disputes due to conflicting terms. So again, we can use parental leave as an example there. Non-compliance with legal obligations. Increased exposure during labor inspections or disputes. So that can lead to compliance orders. There might be somebody that comes out to do an inspection and you have outdated contracts or you don't have contracts available, then the Department of Labor would issue a compliance order. And employee confusion about rights and responsibilities. So if we don't have clear policies or code of conduct, then employees might not know exactly what the rules are and how they need to act in certain situations. An example is an outdated disciplinary policy. So an employer relies on a disciplinary procedure that doesn't reflect current labor law principles and dismisses an employee without a fair opportunity to respond. So if they dismiss an employee, like Lizca mentioned earlier, and they didn't follow a hearing or a proper procedure, then the employee approaches the CCMA and the dismissal may be challenged and they would find that it would be procedurally unfair. Employer best practice is that employers should review contracts and policies regularly. They need to update documents when legislation changes, ensure policies align with actual workplace practices, train their managers and supervisors on updated procedures. They can obtain professional advice when making significant changes. If you're unsure, then you can always contact somebody like us where we can give you the correct policies, or we can assist to just review your current policies and let you know what needs to change, and ensure employees understand their revised policies. So if anything does change, it's always best to have a consultation or put up a notice informing employees that there have been changes and ensure that they understand it.
All right, thank you, Shannen. I'm back, ladies and gents. Mistake number 7, failing to conduct proper workplace investigations. And this is also a common mistake because employers tend to think that if something happens, I can just go straight to disciplinary hearing. You need to do a proper workplace investigation. In other words, a proper workplace investigation is an essential part of fair employee management. Failing to investigate allegations of misconduct, complaints, grievances, or workplace incidents can result in unfair decisions, legal disputes, and damage to workplace trust. A proper investigation helps an employer to determine. Now, this, for example, if somebody is going to come to you with a complaint, Mr. A assaulted Mr. B because of an argument that happened 3 weeks ago. That's the complaint. Now, a proper investigation will help you to determine whether it's misconduct or poor work performance. In other words, is the assault poor work performance? But obviously it would be misconduct. Is there sufficient evidence? Did anybody see this fighting or this assault taking place? Is the employee's explanation credible? In other words, before we get to that point, with the investigation, you would need to call in the relevant parties or the relevant employee to find out what is his version. Would disciplinary action be appropriate? Well, in this case, it would be because it's an assault. And would alternative corrective measures be more suitable? If you listen to it and you find out that it was just a slight disagreement, then let's move that to employees. Otherwise, it would go straight into a disciplinary hearing. Incorrect approach, and this is a good example, an employee is accused of theft. The employer accepts the allegation as true dismisses the employee immediately and only later, as you can see, the $1 million word, there is later attempts to gather evidence. The risk here for the employer is that the dismissal may be found to be unfair because the employer acted without properly establishing the facts and allowing a fair opportunity to respond. So really, employers, you need to do an investigation, okay? The correct approach, the employer gathers relevant evidence. In other words, you ask around, question employees, interviews involved parties, as I've already mentioned, reviews available records, gives the employee an opportunity to provide their version, and then, as you can see, and then decides on the appropriate action. Consequences of poor investigations, employers may face unfair dismissal findings, compensation or reinstatement awards at the CCMA, and unsuccessful disciplinary proceedings. That would, for example, be that it would be a not guilty finding, and whilst you were all emotional and you thought, I'm finally going to get rid of this problem child, now there's not enough evidence, or you didn't do your proper investigation, that would lead to a not guilty finding, and then you're very unhappy, all right? Employers' best practice, and ladies and gents, I want you to take note of this. Employers should investigate complaints promptly and objectively. All right, we take the emotion out of it. Separate the investigation from the final decision-making process where possible. Collect and preserve relevant evidence. Give the employees an opportunity to respond to the allegations. Keep detailed investigation records. Once again, keep record. Ensure confidentiality and avoid prejudging the outcome. Now, a lot of employees tend to say that you've already made up your mind, you're going to fire me. We don't want that. So ensure confidentiality and avoid prejudging the outcome. And important, apply findings consistently, like Shannen also now explained about inconsistency and consistency. Apply findings consistently. That's point number 7. If we go to mistake number 8, failing to consult during retrenchments or temporary layoffs. In other words, this is a procedure or process like retrenchment or temporary layoffs. Failing to consult properly during retrenchments or temporary layoffs is a serious employer mistake. It's like people tend to say that it's like clear as daylight, we're going to close our business. There's nothing going on. Why should I still consult with the employees in terms of the law? South African labor law requires employers to engage in a meaningful consultation process before making decisions based on operational requirements. Common employer mistakes: informing the employees that they have already been retrenched before consultation takes place. In other words, an employer tells the employees, listen here, we're closing down our business. Your last working day would be the end of August. There has been no notification, no consultation. That is wrong. That's a common mistake there. Treating the consultation as a formality rather than a genuine engagement. What we tend to do when we assist employers during a retrenchment consultation is to give the employee the opportunity to respond to the employer's explanations or to ask questions, okay? Failing to provide employees or representatives with relevant information, not considering alternatives to dismissal or layoff, unilaterally reducing working hours or placing employees on unpaid temporary layoff, and failing to follow agreed procedures in collective agreements or workplace policies. The legal position is quite clear. The Labour Relations Act requires employers contemplating dismissals for operational requirements to follow a fair consultation process. We cannot get away from this, ladies and gents. There needs to be a consultation process, all right? Retrenchments must be both substantively fair, based on genuine operational needs. In other words, financial, technological, structural reasons that we're now retrenching or going through this process, and procedurally fair. It's conducted through a meaningful consultation process. So that's the retrenchment part. I'm going to say again, it's a given. We're closing down our business. We're moving on or we're moving overseas. But we must still go through that consultation process and go through all the relevant points as noted in the notice of the consultation and give the employee the opportunities to respond or to reply to that, okay? Now we get to temporary layoffs. Now, temporary layoffs may also create legal risks if imposed without proper authority or agreement. Once again, there's the million-dollar word, ladies and gents, agreement. Employers should consider whether the employment contract allows for temporary layoffs, whether there's a collective agreement, whether a collective agreement applies, whether employees or representatives have been properly consulted, and whether alternatives have been considered. Employer cannot simply stop paying employees or suspend work arrangements without a lawful basis. In other words, if business, you're going to renovate your business now and employees need to be laid off for, let's say, 4 weeks or so, then there's a process that needs to be followed. You cannot just say today, sorry guys, for the next 4 weeks, you're going to be without any salary, we don't going to work, shut down and all of this, and I will see you in the on week number 5. That's going to be, that's a mistake, and it can create risks for the employer. For example, a company experiences financial difficulties. In other words, business is quiet and sends the employees home without pay, without informing them that they will be contacted, or informing them that they will be contacted when business improves. That's wrong. The risk there is employees may challenge the decision because it was no agreement and no fair process. In other words, if you notice, ladies and gents, that business is down or due to financial reasons, I won't be able to have all 10 employees or my whole staff here, and we're going to be on layoff up until where business will improve or the financial situation of the company will improve. There needs to be a consultation. We reach an agreement. You can ask for our assistance from SMIEO to come and assist you, and then obviously draft the documentation that's relevant to that. The correct approach would be the employee explains the operational challenges. In other words, financial reasons, provides relevant information, consults with the affected employees or representatives, considers alternatives. Maybe we can look at a 3-day work week instead of a 5-day work week, and documents the outcome. Consequences of failing to consult. It means that it's a procedurally unfair retrenchment. If the employee is going to refer the matter to the CCMA or the bargaining council, it can lead to a compensation or a reinstatement claims. It would be an unsuccessful defense of labor disputes and delays and increased costs. Employers' best practice. Please take note, employers. Employers should start consultation before making final decisions. All right. And once again, minuted, recorded, take notes of that. Provide meaningful information supporting the proposed retrenchment or layoff. Employees tend to say, ladies and gents, when we have this consultation, that I thought everything was fine in the business. We didn't know that business was down or the employee had problems with the finances. So you need to keep your employees updated regarding this, all right? Consider alternatives, including reduced hours, voluntary measures, or temporary arrangements. Important, consult in good faith, okay? Keep accurate records of meetings, proposals, and responses, and then follow the requirements of the Labor Relations Act and any applicable agreements. So that was mistake number 8, failing to consult during retrenchments or temporary layoffs. Now we go to number 9. Waiting too long to address workplace issues. I think this is also one of the most common mistakes. Like, I don't know if employers, they don't want to take action or they think about that and I'll just give you another chance. And then we sit with this big mistake. Delaying action on workplace problems is a common employer mistake that can allow issues to escalate and create greater legal and operational risks. Employers who ignore misconduct, poor performance, conflict, or employee complaints may later struggle to justify decisions taken after a long delay. I'm just going to give you an example. We're currently dealing with a matter where the manager assaulted her subordinate, but she also indicated, and she referred the matter now to the CCMA, she was dismissed for that, but she indicated that she informed the employer on numerous occasions that this woman was all in her face, she's not listening to her, she's not complying with the instructions, and the employer didn't do anything about it. And up until the stage where she now really just got tired of it and she assaulted, not to justify her behavior. But here the employer would need to prove that we've attended to those grievances or those complaints. So it's important, ladies and gents, to also, not just from the disciplinary point of view, but also to address or to attend to employee complaints that may later struggle to justify decisions taken after a long delay. Common employer mistakes: ignoring repeated misconduct or policy violations, allowing poor performance to continue without intervention, like Shannen explained, like, the person's not meeting or reaching the sales target, but it goes on and on and on, and you don't take any action. Delaying investigations into complaints or grievances, just the one that I've also explained to you. If somebody comes to you and they've got a complaint, it's the employer's duty to investigate that, not for you to come back to the employer. Avoiding difficult conversations with employees. Yeah, I know employers don't like that, but you need to attend to that. Failing to provide timely feedback or corrective guidance, and acting only after the problem has become severe. Unreasonable delays may create problems such as the following: condonation. In other words, by failing to act, an employer may appear to have accepted or tolerated the employee's conduct. An employee would think that, oh, it's okay, I've been absent or I've been coming late for the past month, nothing happened, so I can go into month number 2 and also report late for duty because the employer didn't take any action, so the employer is condoning that type of behavior. Weak evidence, memories fade, documents may be lost, and witnesses may become unavailable. So in other words, if somebody comes with a complaint to you or an incident report to say that, once again, the assault issue or a theft matter, and you don't do any investigation or you take too long to take actions, people tend to forget, like they say, memories fade, documents get lost, and witnesses may then become unavailable. In other words, your main witness resign, goes to a new workplace, and then you sit with the difficulty of proving that matter. Unfairness arguments. Employees may argue that the employer's delay made the disciplinary action unfair. When we sit in disciplinary hearings, so when we chair hearings, employees tend to say, but ma'am, why is the employer only taking action now for being absent in May or in June? We're already going into August, ma'am. Why didn't they take action? So that delay may make the disciplinary action unfair. Escalation of problems. Small issues can develop into serious workplace disputes. The example here: incorrect approach. An employee repeatedly breaches workplace rules for several months, but management takes no action. Let's take the common one, late coming. Every month this person is late, but management takes no action. The employer later dismisses the employee for the accumulated misconduct. So for the month of May, I was late, June, I was late, July, I was late, August, the employer decides, now let's come, I'm going to send you to a disciplinary hearing for reporting late for 4 months. and then I'm going to dismiss you. That's the incorrect approach. The risk there is the employee may argue that the employer tolerated the behavior or failed to act consistently. Employers, that is the employee's best defense. Please do not underestimate the intelligence of employees. They tend to come up with brilliant defenses. And one of that is that, but the employer didn't have a problem with me coming late for duty. Why is it now all of a sudden an issue? Okay. The correct approach would be the employer addresses misconduct promptly, important promptly, investigates the facts, provides corrective guidance where appropriate, and follows a fair disciplinary process if required. I'm going to say it again. The employer addresses misconduct promptly as soon as possible. Investigates it, provides corrective guidance where appropriate, and follows a fair disciplinary process if required. Employers' best practice, employers should, 1, address concerns as soon as they arise, investigate the complaints promptly. Can you see this word promptly just coming up all the time, all right? Provide regular performance feedback, apply policies consistently, keep written records of discussions and actions taken, and train managers to identify and deal with workplace issues early. All right? So that is mistake number 9, waiting too long to address workplace problems. And now we're going to the final mistake, ladies and gents, incorrect management of leave. Now, this is a common mistake that can lead to disputes, financial claims, and non-compliance with labor laws. All right? Employers must ensure that the leave is properly recorded. 1, it's approved and administered in accordance with applicable legislation and company policies. The common employer mistakes would be the following: failing to keep accurate leave records, refusing employees their lawful leave entitlements, incorrectly calculating leave balances, not applying leave rules consistently, and allowing leave practices that conflict with legal requirements. The employer's best practice would be maintain accurate leave records, communicate clear leave procedures. In other words, have a leave policy to say that, and I know a lot of companies, they have it during, let's say from November to January, you're not allowed to take leave because it's a busy period or due to operational requirements. You need to apply 2 weeks in advance for your leave. Make sure that the employees knows, because sometimes employees think that once I hand in my leave form, then the leave has been approved. The leave form needs to be given back to the employee to show that it's signed off by the employer and it has been approved, okay? Communicate the clear leave procedures. Ensure that your managers are properly trained to handle leave requests fairly and consistently. Like I've just explained to you now, there's a leave policy and this is how we need to go about it, okay? And that, ladies and gentlemen, is the end of our presentation. Any questions? Please feel free.
Lizca, there's a question in the comments.
Okay. Because I give out prizes, eh? All right. When considering consistency, does the level matter? So should the managers and junior employees also be treated the same? Or do we consider that management has more responsibility and accountability? Okay, the treated the same. For me, it's like everybody should be treated the same. and to be consistent. In other words, if the manager, and I think there's like just yesterday, I finalized the matter for senior manager. The senior management or management is supposed to set an example. So if that manager commits misconduct, same must be treated in the same manner like the guy that's working on the line, if I can put it that way, or with production. So there should not be that difference.
Sorry, let's go. Treated the same, yes, but I think you also mean maybe a manager or somebody in a more senior position can be held to a higher level of accountability or responsibility.
Definitely. Okay, there's another one, Megan. In terms of performance, let me just find out, Lerato, did that answer your question? Okay. In terms of performance improvement plans regarding non-performance, can we follow our own internal processes and policies as an international company, or do we have to comply to South African law? Obviously, you have to comply to South African law. I don't have a problem with your following your internal processes or policies. And obviously, if it gets to the point where we get to the inquiry phase, it needs to be in terms of the South African labor law, because that person would then be dismissed based on that if it's here in South Africa. Another one, Molly. I have a question regarding rates of employees calculated wrong, both different from payslip. I think, Molly, you would need to speak to your accountant or the payroll system, because it needs to be correct, because that would lead to compliance issues that you're not paying your employees correctly, that the pay rate, should be the correct rate on the payslip. You cannot sit with two different pay rates. And if it gets to the CCMA, we call it a Section 73 dispute. Employee is going to say, but my contract, for example, says I must get 30 Rand per hour, but according to my payslip, I'm getting 29 Rand per hour. So that needs to be rectified as soon as possible, please.
I think, sorry, let's just add, Molly, you can let us know what you mean by your question, or if we've answered it. But if you mean there's one person doing the payroll and they've made a mistake, you can definitely discipline them for that as well. So that could be negligence, depending if it's a system problem or if it's a human error. Does that answer your question, Molly? Do you want to add anything?
Okay, there's a thumbs up. Thank you, Molly. Okay, then we've got Siabulela. Can an employer conduct performance counseling during the probation period once the employee has been fully trained and has shown competence in their tasks and duty? Then thereafter, their performance drops during probation. Can the employer conduct performance counseling under those circumstances? 100% correct, Siabulela. You can do that. That tends to be the thing, that you've got this brilliant employee during probation, and all of a sudden, once the employee has now been permanent and everything, now there's, like you said, the dip in their performance. Then you can start with your performance processes. You, by all means, you're welcome. You can do that. You will be within your rights. Okay. Does that answer your question, Sia? There's a thumbs up, eh? Yeah. Okay. Right. Then we got Karisha. Okay. Karisha. Am I pronouncing it correctly?
Morning.
Morning.
Hi there.
How are you?
Good, thanks in yourselves. That is actually not Karisa, it's Sajida. I just got a question with regards to outdated contracts. If we need to update permanent contracts, right? How do we go about doing it? Because we have some employees that just refuse to sign a new contract.
Okay, if it's a case like that, then obviously you can just, if it's like specific, like you can do an addendum to it. And I can say to them that, guys, this is just to update it. For example, if you look at that parental issue, we've got a parental leave policy, and then we just ask the employees to sign. If they refuse to sign and there's no valid reason, I'll just make a note on it. Then I have it for record purposes that the employee's got no valid reason for signing it. And I know the old people, they tend to be like, why are you giving me something new now? That's understandable, it's human. But if we can just explain to them, we need to update it. For example, if there's a new policy, let's say you implement a dress code policy and you need to attach that to the contract of employment, then it needs to still be explained to them and to say that, guys, this will be the new policy, and the employer will implement it. And if they're still now being difficult about it, my dear, then I would just make a note on it. Employee refused to sign, no valid reason. That employee will still be bound to those same rules.
Okay, but then it will get obviously attached to the original.
100%, 100%, yes.
Okay, thank you so
Thank
much.
you. Carissa. Hello, Carissa. Okay, okay. Maxine, good morning.
Morning. I just
How are
wanted
you?
to check with you. Good, and you?
I'm all right.
Good. I just wanted to check in terms of, so we've got a lot of contract employees and who work on projects, and when the project is coming to an end, we'll issue a notice to say thank you so much, the project's coming to an end and therefore your contract is terminating. A trend that I've noticed is that when I issue my employees with that letter to say, you know, the project's ending in the next week and a half, they often leave us. Like, they'll drop us. That last week they'll find another job and sort of drop us with 1 day's notice, sometimes even less than. In that case, is it still okay to deduct a 1 week's notice? Like, so our contracts say if you're employed less than 6 months, we need 1 week's notice or deduction in lieu of notice. In that case, do we have a right to deduct that week when their contract is ending?
Yes, it should just be clearly stipulated. There's basically two views, if I'm correct, Shannen, because some commissioners at the CCMA says that there should be something separate because it's now a deduction. But it can still be argued that if it's in your contract of employment, that the employer's got the right to deduct that notice period from any money that's still due to me. If I fail or refuse to work out my notice period, I still feel you can still argue that matter and deduct that money.
Okay, super. Thank you.
All right. Thanks, dear. Okay, there's one. Okay, I have a question. It's okay. Okay, Olabogging or magic? But that's Sia's question.
Yeah, he just said he has a question.
Okay, Magic, your question? Okay, let's go on to Sia. Sia, I know the code of good practice is somewhat mute on the procedure for terminating the employment contract during the probation period if the employee is not suitable. What is the correct procedure for terminating the employment contract? Can I just let the employee go and advise them verbally, or should I initiate an incapacity hearing or the poor performance meeting to provide them with an opportunity to respond before I terminate the contract? Or should the employer wait for the end of the probation period to terminate, or can I terminate during the probation period once the employer has been trained? Just need clarity on the proper procedure, the best practice to terminate employment. I love this here that you've listened to best practice, to terminate the employment during the probation period. Bottom line is that a probation period employee should be treated the same way like a permanent employee. A couple of years ago, you could have said, if I'm not happy with your performance after completion of your probation, bye-bye. So if during, let's say, the first month, you notice that you're not happy with my performance, you call me in and you start initiating the poor work performance procedure. And then you minute everything, you record everything, give the employee the opportunity to improve. If we get to the point, let's say, for example, it's now 3 months later and you're still unhappy, you can always extend the probation period. Hopefully, it will be in your contract of employment. Ladies and gents, just ensure that under probation period in your contracts of employment, the clause is there that the employee's got the right to extend the probation period. You can do so, and then obviously follow that process and get to the inquiry phase, and then you can indicate to the employee, we've had meetings, we're at the inquiry phase, you have not improved, we've given you the opportunity to improve, we've asked you how can we assist, and then we can terminate at that point in time. Yes, fortunately, there is a clause. There we go. Thank you, Sia. All right, and then, okay, Magic, good morning. Magic, we can't hear you. Okay, Magic, okay, we can't hear you, Magic. Magic. All right. If we can go to Tarisha.
Hi, can you hear me?
Yes, we can hear you. We can't hear Magic, or yeah,
Oh.
but we can attend to your question so long, my dear.
Okay. The question I have is, do I treat the following as retrenchment? What's happening is we extending a part of the business and the role is now changed. So we're going to need somebody that's a little bit more qualified. So the current person doesn't fulfill the requirements of the job any longer. So how do I treat dismissing this person now? Because we are going to have to get rid of them and put out an advert for a more qualified senior person. So do I treat this as retrenchment?
Yes, because you're now restructuring your business. In other words, that person must get notification, and we need to have a consultation in terms of Section 189, and then discuss all of those alternatives with the employee.
Okay, and then, okay, then the second question is tolerating poor work performance. When am I putting myself at a risk as the employer? Like, how long is too long?
Too long is 2 days.
Oh, flip. Okay.
No, if you notice, or if the performance standard is clear, I'm not performing according to your standard. If I'm a new employee, I would still give that person, let's say, 3 weeks, 4 weeks, a month. Then you call me, let's say, Lizca, I've noticed that your performance is not up to standard. Let's start this process. Maybe there's something that this person doesn't know or needs training or assistance on, and then we take the process from there. You understand? I don't want a situation where, for example, you wait 3 months, like Sia asked, end of probation. Should you now only start the process at that point in time? No, you don't need to wait for that so long. No.
Okay, perfect. Thanks.
All right, pleasure. We're back to Magic. Magic, can you hear us? Magic.
Magic, your mic is muted, so we can't hear you.
There we go. Is that Magic? Oh, feed him. Okay. Magic, your mic is muted. We can't hear you.
Is Magic toss out? Because we not speak toss another.
Okay, no, there's Magic on. His mic is down. No, but his mic is no longer, is unmuted. Thank you, Kenny. Magic, good morning.
Good morning, madam. How are you?
I'm good, and you, Magic?
I'm good. I think I have a serious problem with some of our counterparts employers, because in most cases, currently there was a case of which I was called to actually preside over for a retrenchment process. And I figure out during the process that actually the process was already done by the employer, because they give me the instruction to actually end up unfairly retrenching employees, of which the matter now is before the Labour Court in Brandfontein currently as we speak, because they didn't actually follow the due processes in terms of the LRA subsection 3 of section 189.
Well, if it's
Yeah.
already before the court, then that's already an indication that it's now, if I can say, it's too late to take it back, if you understand what I'm saying. Matter has been dealt with, it has been finalized. If the employer did not follow due processes, like you've indicated in terms of the act, like I've explained, that there needs to be proper consultation in terms of the LRA of section 189, and the correct processes need to be followed. If that's not done, then the employer stands the risks of sitting with a situation like this.
I did honestly advise the employer that dismissing the employee based on a retrenchment when we did not actually follow the due processes, it will come back hunting the employer. That's what I have told them. But they gave me the instruction to say you must go ahead retrenching those individual employees. As I speak right now, the matter is before the Labour Court.
You see, Magic, and that's the purpose of today's webinar. It's the topic is common mistakes. Now, if you make those mistakes and you don't comply with the law, then obviously you will sit with compensation awards or reinstatement or re-employment, you understand? And that's unfortunately why we're advising employers, this is the legal position, please follow that. Because if you're going to do something else, then you're going to end up in trouble. Like you said, it's going to haunt you.
Yes.
All right. Did that answer your question, Magic?
Yeah, I'm covered. That was the concern that I was only having from my side now.
It's a genuine concern. All right. Thank you, Magic. All right. Sia, with regards to handling poor work performance and performance counseling, how does one gauge a reasonable time frame for a performance improvement plan? For example, if an employee performs a repetitive task on a daily basis, saying what is a reasonable time frame to expect improvement from employees who perform tasks of the same? Or can I advise you? Okay, 7 working days to review the performance. And the past I've even advised 3 days. If it's a repetitive thing, Sia, then we can look at 7 days. If it's a sales related task where you can now really need to give this person the opportunity to improve, we normally look at the 4-week period. Some employers look at the 2-week period. You know the nature of your business or your industry, and you know for a fact that it's either you can do the job or not. 7 days would be enough to show if there's an improvement or not. But at the end of the day, you would need to justify from the employer side that 7 days, that was now sufficient time for the employee to improve. Is that fine, Sia? All right, it seems it's in order. Any other questions, ladies and gents? I was getting excited now with all these chats and everybody that's asking these questions. Molly had a question. Oh, it's the same. Yes. Okay.
Yes, good morning, everyone.
Morning, Molly.
Yes, I'm glad that you guys can hear me. There was a great session there. I loved it, and I love the information that you gave. I have a question regarding contracts. The employer that I'm currently working for, and I'm working currently under the HR position. So the employer is the one that has the final say when it comes to everything related within the company. So now the employer has mentioned that he is actually giving employees fixed term contracts. Sometimes it's 1 month for every employee. So each and every employee, when the contract ends after 1 month, it has to renew or he has not to renew. It doesn't matter whether it's an old employee from 3 years back, but he still operates on fixed term contracts. Maximum is mostly 3 months that he gives to his employees. So now my concern is that is it a good procedure to approach when it comes to giving employees 1 month to 3 month contract, especially if there's employees that have a long period of 3 years working within the company?
All right, it is a concern, Molly. You cannot change the status of an employee. In other words, if it's permanent employees and they've been there forever, and they've got permanent contracts, we cannot go change their contracts now to fix term contracts. Or in cases like that, it can be a concern for the employer that you've created the expectation of employment by renewing and renewing and renewing fixed term contracts. And we must always keep in mind the reason for a fixed term contract is that there needs to be a genuine reason for giving the employee a fixed term contract. For example, I think in Maxine's case, they work on projects. So there's a project why they employ a specific employee, and that person will then go on to a fixed term contract. But to change the status, if I can put it that way, from permanent and now you give me a fixed term contract, that would be a concern for the employer and can be a risk for the employer as well.
And what if it's a case whereby the employer never gave the employees a permanent contract, but what I've noticed that in a case whereby is giving them fixed term contracts, it's either an issue of trying not to renew their positions or to cut off their salaries. What if it's an issue like that?
Now that's a major no-go zone. We need them to rectify that and either appoint these employees and give them the correct contracts, because that is a risk for the employer. Like I said, we cannot use the fixed term contract as a shortcut to certain things, if you understand what I'm saying.
Yes.
Because it will create risk. It will end up at the CCMA or bargaining council. So the employer needs to get that in place now.
Okay, so the employee can actually question that when it comes to the labor relations, that they having a fixed term contract because of whatever issues, especially the salary cut.
Yes, that's the one thing. Number two, normally, let's say that the employer doesn't renew the contract again. Then there's a risk for the employer to say, the employee can turn around to say that I've been here forever. And I thought that because of all these 100 renewals, I'm now a permanent employee. And now all of a sudden I get notice your contract is, I'm not going to get the new fixed term contract. And that's a huge risk for the employer. So that needs to be rectified, you understand?
Okay, thank you very much for that.
All right, thank you so much, Molly.
Thank you.
Carissa?
Sorry, just to add on with regards to Molly's question. How long is it that you can renew a fixed term contract? So for example, let's say we give a 1 month contract and then thereafter a 2 month contract. How many renewals can you give?
It comes back to the reason. Why are you giving me a fixed term contract in the first place? Are you giving it to me because there's a genuine operational reason for it? And the example that I always use is that somebody goes on maternity leave and you need somebody to replace that for that position. You would give that person a fixed term contract. But if you're using the fixed term contract just to check out my performance, then we're going to sit with a risk or problem for the employer. And then you're going to sit with the question of how many times can you renew it? Some people say that 2 times is okay, but after the second time, you need to give me the person in a permanent contract. Alternatively, they just look at the one fixed term contract, and after that, the employer needs to decide. But it's going to come back to, why are you giving me a fixed term contract in the first place?
Okay, if it is with regards to probation period and looking to see if you are suitable for the role,
See, there's the problem. You cannot use the
Yeah.
fixed term contract to do that, you understand. And then it's going to come back to see a situation that he mentioned earlier on to say that the person has been brilliant during the, let's say you give me a 3 months fixed term contract. I'm a brilliant employee. Now you decide, okay, I'm going to give you a permanent contract, Lizca. Now I start with my nonsense. Then you back to square one, if you understand what I'm saying.
Yes.
All right.
Oh,
Thanks,
thank you.
Carissa. Thanks, my dear. All right, Sia, how many performance counseling sessions are reasonable? Can I recommend 3? Performance counseling to management before, yes, initiating an incapacity hearing. My concern is that the performance counseling process takes 7 working days per session. Ultimately, the employee will either be demoted, reassigned, or dismissed. Is that substantively fair? I can see the above question is continuation of my previous question.
I think again, Sia, it depends on the industry and what the employee is doing and how much time they're going to need. Because, for example, if you have a car salesman, they might need a lot more time, or more space in between the sessions to check on their improvement. If it's somebody like you mentioned earlier, where it's a repetitive task, they need to do it all day, every day, you'd be able to see. I think 3 is sufficient. So, like you said, it takes about 7 working days because you need to monitor the performance, but then 3 is sufficient. And I think that would then be fair to dismiss them after that. As long as you've checked in to see, has there been improvement? If there's no improvement, then dismissing for poor work performance. I feel that would be fair. You followed the correct procedure and it's a valid and fair reason for a dismissal.
100%.
Does that answer your question, Sia? Okay.
Okay. Any other questions, ladies and gents? Right, let's just check the others. Don't see any hands. Right. All right. Everybody. Thank you, everybody. It was nice starting with Women's Month. Okay, we're nearly there. Almost, yeah. With you all, and we hope and trust and believe that if should there be any issues, please feel free to contact our organization and we'll give you the necessary assistance. Thank you so much. Thank you, Shani, for assisting me. And yeah, have a good day and stay blessed, everybody. Bye-bye.
Have a good day.